Today, we're going to be talking about the 10 different steps in the context of legal representation following an accident or an injury. So, if you've been injured in an accident, a car accident, some other form of an accident, product, you've been hurt at work, uh, you find yourself looking for a lawyer. You contact our office, we have a consultation. We've now entered into the first phase or the first step in the legal representation process. That's the investigation step. So this is the step at which our firm will investigate, find out what happened. We need to find out who was at fault, where it happened, all of the basic logistics of it. We need to do any investigation necessary, talk to any witnesses necessary, and then we need to look at your medical information. How were you injured? To what extent were you injured? What type of medical treatment have you had? We need to gather up your records, and we need to get an idea of what your long-term prognosis looks like. And that can vary very significantly from case to case. But during this stage of the process, this is a pre-suit stage, and this is the early stage where we'll be a lot of back and forth with you, trying to determine exactly what happened and exactly what this looks like. Once we've completed the initial investigation stage of the case, we move on to stage two, which in most cases is the demand stage. Now, keep in mind that we still have not filed a lawsuit, so we are still outside of a formal legal proceeding, but you're working with our office, and we've gathered up all the information that we need in order to have made an assessment of your case. Now, ordinarily, the demand stage will come when you've either finished your medical treatment or we have a good idea of what your future medical treatment will look like. And in the demand stage, we will then prepare a demand to go to the insurance company for the wrongdoer that lays out our assessment of the liability or who is at fault, as well as your damages. And then we will make a demand to the insurance company for a certain amount of money to settle the claim prior to filing a lawsuit. Again, in stage two, we are not yet in a lawsuit. And so this is the only stage or the last stage where it is private. It is not publicly filed. And any resolution at this point is not a matter of public record. Now, for many clients, this is actually important. Lots of people come to us, whether they're professionals, they're members of the public who are in the spotlight. For whatever reason, they don't want a public record of any kind of legal claim, and they ask us to try to resolve it quietly and confidentially. If that is the case, then we would try to resolve the claim in stage two, which is that demand stage. If it's unsuccessful, we would then move to stage three, which is the filing of the actual lawsuit. That is a stage where we then work with you. We draft what's called a complaint, which is the document that is necessary to start a lawsuit. And we file it electronically with whatever court is the appropriate court in which the lawsuit should be filed. Typically, that's the county where the accident happened, but occasionally there are other considerations that go into where the case is filed. So we prepare the complaint and we file it, and then we have to serve it on the wrongdoer. So if that's an individual, we would have it personally served on them. If it's a business or a company, we would have it served either at the business or through the New York State Department of State. There's a number of ways that the claim is served, but this is a formal commencement of an actual legal action. This is public. It can be found online through somewhat diligent research, and it is now a much formal process. So once we get through the filing of the lawsuit stage, we then move on to the next stage. And stage four, which is the discovery stage, starts when the defendant has responded to that complaint that we filed in stage three. So the defendant gets served with the complaint. They typically will pass it on to their insurance company, who will assign them an attorney. And then that attorney will file what's called an answer. An answer is simply a document that in almost every case denies that they did anything wrong, and moves us on to stage four, which is the early discovery part of the case. And I say early because there are multiple parts of discovery. So in stage four, this is an opportunity for each side to discover what the other side knows about the case. So if you're the plaintiff, if you're the person who has been hurt, we will use this opportunity to ask the defense for any kind of records, documentation, photographs, insurance information, or other information that we think would be helpful in proving our claim. The defense, the person who is the alleged wrongdoer, will serve us with demands asking us to specify the allegations against them, to make specific allegations of what exactly they did wrong. They'll also ask for any information that we have, photographs, reports, any other kind of documentation that helps support our claim. And probably most importantly, they'll ask for information about witnesses and also information about your medical treatment. They'll ask for medical authorizations, which will allow them to get records from the providers who treated you for the medical injuries that you have sustained as a result of the accident. Now, one thing to keep in mind is that in this stage of the process, defendants will often ask for records that go back well before the accident took place, because they want to know what your medical history was in order to determine if any of the injuries that you're claiming in this case are actually the result of some prior injury that you had way back when. Plaintiffs often get frustrated by this process, but it's generally permissible. There are some times when we oppose it, but for the most part, this type of thing is permissible. We always tell clients that when you file a lawsuit, you are an open book. Once we get done with the paper discovery part of it, this is about the time in stage 4 where a court or a judge will actually get involved. And the judge will get involved simply to set some deadlines to make sure that the case keeps moving. And the next stage, which is stage 5, is one of the most critical parts of the case, and that's the depositions phase of the case. This is where the parties have exchanged their discovery, they've exchanged their materials, they have a good idea of what the claims look like, of what the injuries look like, and now it's an opportunity to talk to one another and ask questions under oath about how the accident happened, about what the medical injuries are. So depositions are important. It is not trial testimony, but it's under oath and it's very important. So we talk with clients well in advance to prepare them for the deposition. But if you file a lawsuit, it is likely that you will have to give a deposition in stage 5. After depositions are complete, we then move on to stage 6, which is the late discovery phase of the case. So now the parties have exchanged their initial paper, they have had depositions, and they are now in the post-deposition phase where they have an opportunity to follow up on any requests, request any new information that has come up during the course of depositions and discovery. And it's often in this case where the defense will have the injured person examined by their own doctor, who will then make an opinion as to the permanency of the injuries. It is also during the stage where there's typically an opportunity to discuss a resolution or a settlement of the claim. And we often explore that around the late discovery phase of the case. If it doesn't happen, then we move into stage 7, which is the pre-trial part of the case. Now, this is the time when everybody knows what the case is about. Maybe the case has not settled yet, and the parties are preparing to go to trial. This means lining up witnesses, potentially lining up doctors to testify, and preparing as though the case were going to go to trial and let a jury decide who is right and who is wrong. Now, statistically, most cases don't go to trial, but we always prepare as though they will, because it helps the client, it helps us move forward, move the case along, and frankly, we think that it helps optimize or maximize the recovery for the client. Stage 8 is the trial. Now, many plaintiffs or clients get nervous about the prospect of a trial. Statistically, it's unlikely that a case will go to trial, but again, we always prepare the case for trial. And if it goes to trial in stage 8, then we go in front of a jury, we present our case, the other side presents their case, and then ultimately we let a jury decide who is right and who is wrong, and if they are wrong, what the amount of damages are. Typically, a trial will take anywhere from a few days to a week or maybe 2 weeks, but trials are a critical part of being prepared for the case and being ready. So that's the trial phase. That is stage 8. Stage 9 is settlement. Now, stage 9 can actually occur at any point throughout the case. Settlement often happens through either direct negotiations between the attorneys, or it happens through an alternative method, such as mediation or a settlement conference with a judge. Now, mediation is simply an opportunity for both sides of a lawsuit to sit down with a third party who will try to hash out a settlement between the two. It's that simple. You go back and forth, you work through, you try to get a settlement. Same thing happens with a judge. But that is stage 9. Again, settlement can happen at any point in the case. It happens everywhere from before the case to the middle of the case to the end of the case. So it is something that happens in most cases, not all, but it does fall into the stage 9 category of the legal proceeding. Stage 10 is the case closeout. Now, The case will close out in one of a few ways. Either the case is settled, in which case the parties have agreed to a resolution, they have finalized paperwork, any and all liens, medical liens, have been paid, and the parties sign documents, exchange money, and go about their business and about their lives. Alternatively, there are occasions where the defense will ask a court to dismiss a case for legal reasons. If that happens, that can also lead to stage 10, which is closing out the case. And the other way that this case gets closed out is if there's a jury trial. Once there is a verdict and the verdict has either been appealed or not appealed, eventually we get to the point where the case is over and it's closed out. The typical lifespan of a case is anywhere from 6 months to 18 to 24 months. That all depends upon which stage of the proceeding that the case resolves. But those are the 10 stages of a legal representation relating to an injury. If you have questions, feel free to reach out to us.